So he postpones the case. This is another tactic of the divorce industry. They keep postponing justice. Well, justice delayed is justice denied. And I've heard this from dozens of different fathers over the years. Same thing happens. First they issue a temporary custody order, and pretty much that's going to remain the status quo till your kids reach 18 years of age. Attorney Harding then threatened to withdraw from my case unless I would agree to settle, drop pursuit of custody. In exchange for reduced child support, he basically wanted me to sell my right to a fair hearing, sell my kids. I refused to sell out my right to a custody hearing. Harding withdrew for continuance purposes regarding custody, but handled issuance of a no-fault divorce decree dated 6/27/90 and the signing over of vehicle titles, etc. The matter of custody was thwarted by delay until December 1990. Justice delayed is justice denied. On December 11th, 1990, I was not able to earn enough in Norfolk, where I moved to be near my kids after I finished paralegal school. I was not able to earn enough as a title abstractor to contribute anything toward child support. Even the attorney, Harding, had stated that under the circumstances of having to retrain following injury, little or no child support should have been required. However, at the continuance hearing, I was representing myself, and the only issue allowed was a show cause motion by my ex-wife's attorney for non-payment of the extortion, what they call child support. I was thrown in debtor's prison for 30 days, causing a loss of recently improved earnings from independent contract title work. Again, hearing of the custody issue was thwarted. The money issue prevented a complete divorce hearing. Due process was denied. January 1991. Upon release from jail, I moved back to Arlington for higher wages. I could not earn enough in the Hampton Roads area as a title abstractor and could not find work as a paralegal after applying for numerous job openings. I appealed the divorce decree pro se. December 1991, the Court of Appeals of Virginia affirmed the divorce decree, citing no reversible error, even though a complete divorce hearing on custody, contributions to the marriage, and property rights issues, including the agreement to return to California, never occurred. Due process is denied. 12/30/91, the Supreme Court of Virginia rejected my papers. I could not afford a transcript of the only recorded hearing, 424/89, nor could I afford an attorney. Thus, I could not prepare a proper, quote-unquote, appeal brief. They refused to accept my best efforts to represent myself. So, because I could not afford an attorney, my right to be a father was denied. Due process is denied. In April 1992, I had filed a breach of contract complaint in federal court, and in Arlington Circuit Court and in the U.S. District Court, Eastern Virginia, attempting diversity jurisdiction due to my intent to remain a California resident, being manifested in acceptance to law school. I wasn't sure which court to file in, so I filed in both to meet the deadline for breach of contract statute of limitations. On July 31st, 1992, the U.S. District Court dismissed the breach of contract suit without prejudice due to lack of diversity jurisdiction. Because of the fact I was now a Virginia resident, they didn't have jurisdiction. So they claimed. Federal Judge Ellis suggested I try to file suit in Virginia. 9/2/92 malpractice complaint. I filed a malpractice complaint against Daryl Harding for his advice to waive fault grounds for divorce, reasoning that if the circuit court had not been in error for no divorce hearing, then the attorney's advice to forego fault grounds had to have been the reason for no proper divorce hearing. In responding, both attorneys who were at the 5/31/90 hearing admitted that the judge did say that a full day hearing was necessary, yet it never happened. January 4th, 1993. The Virginia Bar dismissed the malpractice complaint, stating that it was sound legal advice of Harding to drop pursuit of fault grounds, even though dropping fault grounds precluded the full hearing on custody and the contract to return to California, the very issues I hired him to address. Black is white and white is black. Due process is denied. 4/3/93. I served the breach of contract complaint in the Arlington Circuit Court. The case was transferred to Williamsburg and James City County Juvenile and Domestic Relations District Court, JDR Court. On 6/23/93, I filed a petition for sole custody in the Williamsburg JDR Court. August 18th, 93, JDR Court Judge Thomas B. Hoover dismissed the breach of contract complaint for lack of jurisdiction and ordered home studies for determination of custody. October 29th, 1993, sole custody hearing. I severely discredited Kathy and her new husband with statements of the children since 1989. The judge accepted the statements into evidence as true rather than hearing the children's testimony, but he denied the sole custody petition. He ordered Kathy and I to counseling with a mediator for a one-meeting lecture. My right to be a father was denied. Legal issues are diverted into the realm of psychology, adding further insult to injury. 11/19/93, Judge Hoover denied the joint custody petition even though I cited my daughter's statements, which clearly showed her distress due to lies told to her by her mother. The evidence was ignored. My right to be a father was denied. February 25th, 1994. Visitation refusal, arrest for trespassing, hunger strike for justice. Kathy refused my visitation. She had contacted a judge by phone. How she was able to do that, I don't know. Protesting, I was arrested for trespassing at the Williamsburg courthouse in order to immediately speak to a judge or magistrate, as she did, to enforce my visitation order. Kathy was allowed to speak to a judge by phone, but I was thrown in jail for trying to see the magistrate. While incarcerated, I began a hunger strike for justice. March 8, 94. At the hearing on my show cause motion for visitation denial and Kathy's subsequent motion to restrict visitation, Judge Hoover suspended my visitation pending psychological evaluations of both parents and all three children. I refused to cooperate, citing the legal problem of no due process, not a psychological problem, as the cause for the children being in conflict. March 9, 1994, as conditions for ending my 15-day water-only hunger strike, Commonwealth's attorney, Fairbanks, promised 1, my daughter would be allowed to testify to corroborate evidence against her mother. 2, sanctions imposed on me would be lifted. 3, a complete divorce hearing on all divorce matters, which I never had. 4, the trespassing charge would be dismissed.